They kicked in his door, looked for something that wasn't there, found nothing, left $20,000 in damage and a slice of lemon pound cake. So Afroman made a few songs about it to pay for the damages to his property. And when the Adams County Sheriff's Office tried to sue him for nearly $4 million, claiming Afroman's music caused them emotional distress, he showed up to court in an American flag suit, matching sunglasses, and a white fur coat. It all started with a bad tip. August 2022, Winchester, Ohio. Afroman is away from home in Chicago. Adams County officers arrive at his home, break his external gate, smash his door in, and disconnect the wiring of his security cameras. In the story the CI told, Afroman's lawyer called it bad fiction. She alleged Afroman had a dungeon in a basement, except Afroman had no basement. But under Illinois v. Gates, the state is allowed to conduct these invasive searches based on something they call the totality of circumstances. It's a flexible threshold that often legitimizes state intrusion based on unverified or vetted informants, who in this instance possessed a huge motive to lie. So to save herself, she allegedly implicated Afroman to force this raid to even happen. But the state's failure to find any evidence to corroborate the CI's story after the raid didn't result in an apology until after the trial was over. This actually wasn't the first time Afroman wrote and sold a diss track against unjust authority. That happened much earlier in his life. As early as middle school, he wrote his first song aimed at a classroom bully called Harry Carey. Then he moved to mixtapes. The first mixtape he ever made and sold was about an 8th grade teacher who got him kicked out of school. Fast forward to August 2022. Afroman took all of his surveillance footage of the home invasion and made his first protest song, Lemon Pound Cake, based on the officer who eyed the lemon pound cake baked by Afroman's mother sitting under a bell jar in his kitchen.
Mama's lemon pound cake, it tastes so nice.
And the melody of Lemon Pound Cake actually represents something much more than you may think. Under the Boardwalk was first recorded by the Drifters in 1964, and it reached the top 10 on the Billboard charts, the same year the Civil Rights Act passed. And this song moved beyond its original Black cultural context musically almost immediately. Less than 4 months later, on September 2nd, 1964, the Rolling Stones recorded their cover of Under the Boardwalk in London, making it a new international pop standard, with more white commercial appeal following, from the Beach Boys, Bette Midler, and Bruce Willis, to John Mellencamp. So when Afroman reached for that melody, he wasn't just picking a familiar hook. The comfort of that melody sits on top of Black musical labor from a segregated era, and Afroman repurposed that comfort to deliver something deeply uncomfortable. And Afroman released more protest songs to recoup the damages. 7 deputies sued Afroman for nearly $4 million, claiming the videos caused them humiliation, ridicule, and mental distress. Yet the ACLU of Ohio called this defamation lawsuit against Afroman a slap suit, or a strategic lawsuit against public participation, meaning a meritless effort to silence a critic. The deputies were trying to use reputation law to claw back narrative control after Afroman turned a failed raid into a viral joke about police power. But by trying to suppress the embarrassment, they actually amplified it. The trial in March 2026 lasted for 3 days, but it was full of strategic and surprising moments. Afroman's main strategic move was hiring David Osborne, a local attorney with a PhD in chemistry, who had known the officers and the judge his entire life. They used New York Times v. Sullivan for the actual malice standard, and Hustler v. Falwell to protect Afroman's outrageous satire. The defense argued that no reasonable person would take these rap lyrics as literal fact. And he used references to Cardi B and Megan Thee Stallion's WAP and Lil Wayne's Meow Monster to explain how rap often uses exaggeration, shock, and humor.
Rap started out as a means for people to express social commentary, opinions through entertainment. Look at the song by NWA, or they call it The Police. I think I said that right. It's a social commentary on what was going on in their lives. Their personal effect, the personal things happening to them, combined with entertainment, which unfortunately is exaggeration, opinion, nothing of fact in that song. It's a commentary on society. And so when you look at rap, you see that over and over again. Carly B, WAP. I find it bad to say what WAP means, but it's a popular song. I think it's somewhat derogatory, but then again, I'm not the audience for that song, and I know that. I know nothing in that song. I know it's entertainment. I know it's social commentary. Nobody looks at Lil Wayne's song Monster and says there's a monster in that song. Everybody knows it's exaggeration for entertainment. Is he commenting on something? Sure. But it's not fact.
So Afroman's lawyer was pushing back against a much larger habit of prosecutors, where they strip down rap of metaphor, bravado, humor, and performance, and then hand it to the jury as though every line were sworn testimony. And while the police claimed Afroman's lyrics about their personal life and public records were lies on the stand, Afroman stood his ground and said they were true. He also argued that if the police hadn't wrongly raided his house, he wouldn't even know their name, let alone be rapping about them to make money he needed for the damages.
The sheriff's never supposed to raided my house in the first place. The whole raid was a mistake. All of this is their fault. If they hadn't have wrongly raided my house, there would be no lawsuit. I would not know their names. They wouldn't be on my body. They wouldn't be on my home surveillance system. And there would be no songs, nothing. My money would still be intact, nothing. So all of this is their fault.
The plaintiff's lawyers attempted to moralize the role of the jury, suggesting that they were hand-selected by God to protect the police, a claim the jurors later stated that they found quite odd. Deputy Lisa Phillips actually broke down in tears while a 13-minute music video using targeted innuendos was played for the court. Meanwhile, Sergeant Randy Walters testified that he'd been called a son of a bee. Hours after Walters gave that testimony, Afroman posted a new video to social media.
Randy Walters is the son of a.
And Deputy Sean Cooley, the original Officer Poundcake, testified that he's received hundreds of pound cakes at work from random people.
Sean, you were called Officer Poundcake by Mr. Foreman?
Multiple times.
You
received hundreds of pound cakes at work from different people.
Juror number 5 later revealed that the jurors were instructed to show no emotion, making them look like a bunch of robots to observers. But behind closed doors, the jury would order lemon pound cake for dinner during deliberations. And by the end of deliberations, the jurors didn't find any evidence of damages. So they found Afroman not liable.
America won. America still has freedom of speech. It's still for the people, by the people.
So this was a victory for the First Amendment, but not so much for Afroman as we would come to learn. Judge Jonathan Hines was said to signal visible bias throughout the trial. He was said to undermine and interrupt Afroman's lawyer, and when the time came for the verdict forms to be read, he fumbled through the papers in disbelief. Juror number 5 said you could just feel it. Afroman called him lackluster when he read the verdict, and it was said that the judge left abruptly after reading it.
So the verdict forms are properly executed, properly completed. Copies will be made available to the parties. In all circumstances, the jury finds in favor of the defendant. No plaintiff verdict prevailed. So the matter will be concluded with defense verdicts. Thank you, Mr. Klingler. Thank you, Mr. Osborne. Thank you to the court staff and the Sheriff's Department for security in the building. And we'll go ahead and stand adjournment. You're welcome.
If the plaintiffs would have won, I believe that judge would have read everything like some Englishman in a square, like, here. The plaintiffs, they get this, that, and the other. But I think he looked through the paperwork and he's seen that I got cleared on everything. And I think he was so mad that he wanted to stay professional without showing his emotions. And he summed it up as short as possible. and he like just disappeared, and we all had to figure out that court was over and we could go. And my lawyer had to come over and tell me that we won. He had to whisper to me because I didn't know what was I'm like, hey, what happened? I didn't know what he said. He said something really brief and quick, and my lawyer said, hey, he whispered, he said, we've won.
But the judge wasn't done yet, because then came Rule 54. Usually, the winner gets the court cost paid by the loser, so in this case, the officers were supposed to pay. But Judge Hines ordered Afroman to pay half, citing relative merits of the case, an unheard of ruling for a defendant that actually won, which some are calling an outgrowth of racism, or even a structural attempt to reclaim narrative power, since Afroman defeated the state in court. Some are saying that the judge essentially inserted his desires into the result because the jury didn't give him the verdict that he wanted, what can be described as a punished victory. Despite this force of hand to regain power, Afroman still won because he refused to let the state control his narrative, using his camera and his microphone to make protest music, creating a blueprint for forcing institutional power to look back at itself. This is Real Quick Media. Stay tuned for more stories like these in the Black Media Power series playlist. Please be sure to like, comment, share, and subscribe so you don't miss the gems I drop in the next video.